I'm really excited about today's Lunch and Learn. You're going to learn a lot about the legal process, our role, our responsibilities, how we can interact with all the items. So I'm really excited about today's presentation. Many of you have heard Erica already. She normally comes to all of our training classes and speaks. The last, of course, this year that we've been doing Zoom or virtual, she hasn't been able to do those. And then she didn't get to come in January or last September. So if you trained in September or January, I think she had volleyball and basketball or soccer.
Volleyball.
Yeah, volleyball. There was something going on. So I'm really excited to have her today. I'm going to let her tell you a little bit about her history and about her connection to CASA. But Erica is one of the most amazing attorneys in our town. I mean, she's experienced. She worked in the DA's office. You saw that in her bio, and she's involved in so many different things. She was appointed, I believe, by the governor on that water, the
UCRA.
Upper
Colorado River Authority. There's no reason anybody should know that.
Oh, I think it's a cool thing to be appointed to something like that. So that she's an attorney for the parents, she's an attorney for the kids, so she sees it from all perspectives. So what she has to share today will be valuable information. It will be very relevant information. As always, stay on till the end, and we're going to have door prizes at the end. We'll have Erica draw some numbers for us or pick some. And then at the end, as we go along, put your questions in the chat box so that she can review those at the end. And that way you don't forget, but then she'll take questions at the end as well. So Erica, you are going to be able to share your screen and share your slide presentation, but we love Erica Hall. If you ever need an attorney, that's the woman you want to call right there. She's amazing. And I so appreciate your time again, Erica, and it's yours.
Thank you. Well, I just want to say thank you for all of you for taking the time, not just today, but in your volunteer work with CASA. It's just, you fill such a valuable role that we had been missing for a really long time. And CASA came about at the perfect time for Taylor County. Texas CASA had been trying to get CASA going in Taylor County for a long time. And when Judge Hacker and the attorneys got behind it, it was, just a few years before this huge explosion of cases. And so we're extremely grateful for you guys. And I'll talk a little bit more about what positive things other lawyers have to say. As Rebel said, I've done a presentation for some of you in the past where we tracked the family code. And while I think some of that's important, and we'll touch on that really quickly today, I don't think we need to go through 107.006A, B, C, D, and all of that today. So what I wanted to do is just touch on what was important about that, but then I got feedback from CASA, I got feedback from attorney ad litem, and I got feedback from the court to just talk about some things that I think might be helpful that maybe I wish I'd known, maybe you wish you'd known, in the working relationship between attorney ad litems and guardian ad litems. So bear with me, I've never shared my screen. We're gonna try that now. And I believe you should just be able to see the PowerPoint presentation. So just give me a second, I apologize.
And once you share it, if you'll just go to the single little thing, it should pop, the little display thing, it should pop up.
So I need to pull up the presentation first and then share. Sorry, you guys, I even watched YouTube videos about this to make sure
I do have it if you need me to share it.
I've got it right here. I've got it right here. Here it comes. Okay, I'm now going to share screen and let me know if you've got it. You have it?
We do, and then just select that big power thing and the single screen thing at the bottom, and we're good.
The single screen thing at the bottom.
It's on the bottom right, near the 127 Zoom.
Sorry, I have to go back into full screen mode. See you guys, it's not just y'all.
I just do these so much now that I'm kind of
Well, I
getting to
do
be.
all my mediations this way, but it's not letting me go back into full screen mode. Hold on, Rebel. I apologize for the waiting, you guys.
It is okay. We've got plenty of time.
Um, it's not letting me do that. Okay, maybe this will help. Well, Rebel?
Okay, are you looking at where you see your slides on the left and the big one in the middle?
No, oh, I see what you're saying. Just to do this. I got you. I was misunderstanding what to do. So, oh, it should just do the one slide. Sorry, you guys. Technical difficulties, mother, I know. It's horrible. Right there. Are we good?
Yay! Okay,
Okay. All right, guys. Now we can get started. My apologies for that. So, if you know me, I love a little cheesy thing here and there, but teamwork makes the dream work. And it takes both CASA, guardian ad litems, and attorney ad litems to make sure that our kiddos are getting, the full services and attention that they need. This is one of my favorite pictures, and I think y'all do this every year. This might have been from the first year of the Heroes 5K, but this just gives you an example of what an impact you guys make in the community. I mean, if you just look at how many people come out and support CASA, it's not just there in the legal community. So here we have Texas Family Code definitions, yawn. But like I said, we're not going to spend too much time on this. I just think it's important so that we can establish the difference, the clear difference between being a guardian ad litem and an attorney ad litem. And I know that y'all cover that in your training. But under the Texas Family Code, an attorney ad litem means an attorney who provides legal services to a person, including a child, and who owes to the person the duties of undivided loyalty, confidentiality, and competent representation. So the reason that I highlighted undivided loyalty and confidentiality is the biggest difference between an attorney ad litem and a guardian ad litem is that we have to work at the direction of our clients. If our client is old enough, to say what they want, I don't care if they're 8 years old. If they can communicate to you, let's say I want to go home, then it is our job, whether we agree with that or not, to do everything within our power legally to see if we can make that happen. So we owe an undivided loyalty to that client. Also, we have an attorney-client privilege with that client, and everybody hears about that, but this applies no matter how young our clients are. Now, the exception to that, of course, is going to be if our client discloses to us something that's amounts to additional abuse, neglect, or risk that can hurt themselves or others, then we have an obligation, legal obligation to report that. But so it's our job basically to do as we're told, as though our clients were adults that had hired us. Guardian ad litem means a person appointed to represent the best interests of a child. The term includes a volunteer advocate from a charitable organization who is appointed by the court as the child's guardian ad litem. That's you guys. So you have the luxury, and I know that sometimes it does not feel that way, but the luxury of saying, okay, I hear what the children are saying, I hear what the parents are saying, but here's what I think is best for the children, and being able to express what you believe is in their best interest. So you're not tied in the same manner that attorney ad litems are to the direction of their client. Powers and duties of guardian ad litems. That's you fine folks. So it's important to remember, although I know you guys know this, that you're not a party to the suit, but you may conduct an investigation to the extent you consider necessary, obtain and review copies of educational and medical records. Now, when I say conduct an investigation to the extent you consider necessary, nobody can really tell you what that should be, right? So it's what you consider is necessary in a fact-finding mission. Anything that's reasonable. You can talk to anybody that has relevant knowledge or facts or that you believe has those things. We're going to discuss a little bit later what we do when we're challenged with providers not wanting to give you education and medical records. I think you'll find that you can obtain educational records more easily than you can medical records, but you are certainly entitled to all of that. And then you shall, within a reasonable time after appointment, interview the child. And I use child interchangeably with children throughout this presentation. Speak to individuals with significant knowledge and seek to elicit the child's expressed desires. And part of that is in a developmentally appropriate manner. So, I mean, of course, talking to a 4-year-old about what they may want and how they feel is going to be very different than speaking to a 16-year-old. And then take all of that into consideration. Consider the child's expressed objectives, encourage settlement, and that's never been an issue. I've always had CASA be absolutely willing to participate in the settlement process. Perform any specific tasks ordered by the court. This may be, let's say, for example, you have an older child and they're having difficulty obtaining some records, or they need maybe their school transcript and can't seem to get it. The court may say, Mr. and Ms. Casa, can you please work on obtaining those records for the court? So you might be asked to do special things from time to time. And you shall ascertain if the child has identifying documents to include driver's license, social security cards, immunization records, and educational records. To engage can help you obtain a lot of this, and they are the conduit through which to go because they are the conservator, but it often takes somebody with a little more time and attention, such as CASA, to bring it to somebody's attention that this needs to be done and really be the squeaky wheels. It's really a true disservice to our older kiddos when maybe they transition out of the care of the department or their case ends and they don't have these items. It can make it very difficult for them, but especially for those that age out. Now, this is important. You're entitled to receive copies of all pleadings filed, which now that we have e-file, that happens pretty seamlessly. If CASA is on the case, then it automatically gets served electronically to that email address. Notice of hearings, also done through electronic filing. Notice of meetings and staffings. This can be very hit or miss. And I know that a lot of you guys have experienced this. You're entitled to be at any CPS meeting or staffing in which anybody outside of CPS can be there. So permanency conferences, family group meetings, and I know they change the names for these things on a weekly basis, I'm pretty sure, but you're allowed to be part of any of those meetings that affect your child. You're allowed to attend or entitled to attend all court proceedings, but you may not call witnesses, and that's by nature of not being a party to the case. You are also entitled to be consulted regarding placements made and or changes in placement. This is also something that even attorney ad litems get failed to be consulted with and or informed. And that's a really big problem. If you have a child that's moved without you being part of that conversation, you need to bring it to everybody's attention and do not be shy about doing so. You're an integral part of that. And these are conversations that need to be made as a team for each one of our kiddos. And you're entitled to evaluate if welfare services being provided to the child meets their needs. For example, if you feel, I had this happen at the end of last week, if you feel that a certain counselor, let's say, is not effectively communicating with the parties in a way that's helping the child, you have a right to bring up to the parties whether or not this is the right individual to be providing treatment for this kiddo. Or if you have a child that's in traditional counseling, but you believe firmly that they need trauma counseling and that we need to find a specialized counselor that's a counselor that's specialized in trauma, then you have the right to speak up and say, I don't know that this child's needs are being met with provider X, Y, or Z. Sharing is caring, you guys. These are a few thoughts and questions from our guardian and attorney ad litems. And like Rebel said, don't forget to add your questions at the bottom because I left a bunch of time for that. So everybody from both sides, I'd say both sides of the aisle, but that just feels, ugh. Attorney ad litems and guardian ad litems in the court is all saying communication is key. So I had several attorney ad litems say that they find it very helpful when guardian ad litems forward on medical and educational records and notes. Often you guys as CASA just have a closer working relationship with caseworkers and or placements. just by your nature of ability to spend more time with those people. And this can prove very helpful in you obtaining some of those records. So anything you get, you don't even need to ask if the attorney ad litem wants it, just send it on. It is so appreciated. And that way, when you guys are ready to have a conversation about something, you know that they're as well informed as you are. Email is king, and a thread email is even better. It's often difficult for attorneys to take phone calls in the midst of a working day just because we're out in the office, out of the office, in a hearing. And then it's also very time demanding at the end of a day to return those calls. Because as attorneys, we're held to an ethical obligation to return phone calls in a reasonable time, which I, for myself, believe is it within 24 hours. So what's helpful is if you start a thread email with a concern and or a question that has the parties on it, that thread can stay alive. And this is so helpful when you get ready for a hearing or for a trial, because you go back and there it all is. And then if you feel like you're just not getting to the bottom of what needs to be discussed and or solved, request a meeting in person. And I'm going to explain later that the court recommends, if that doesn't work, or if you just feel like it's more time sensitive matter, you're going to ask somebody to set a hearing for you. It's okay to not be on the same page. Now, I know that this sounds very weird, but attorney ad litems for the children, guardian ad litems, and attorney ad litems for parents all have very important but very distinct roles. So it's not that unusual for you to be at odds with the attorney ad litem for the child, and or for the attorney ad litem for the parent. If an attorney ad litem for a child, if their child is directing them to do something that you think is just completely horrible and contrary to the child's best interest, that's going to just by its nature limit y'all's ability to communicate about everything. Because remember, the attorney ad litem has to hold that confidentiality for their client in a way that you don't. And they have to, if it's not criminal and it's not going to hurt them, blindly follow their client's direction, right? Unless there becomes a conflict. So let's say you reach out to an attorney ad litem for your client and say, listen, we need to get on the same page and make sure everybody's in agreement. And don't be alarmed or take it personally if they're like, actually, we don't. That's just not going to happen. And I don't think the conversation is going to be fruitful because I'm just not going to be able to get on the same page as you guys. Some lawyers are better than others at delivering that message in a better tone, I think. What do you mean you refuse to give me the records? The court said I'm entitled to them. And so does the family code, by the way. So the order appointing the guardian ad litem is all by law that a medical provider or any other provider should need to produce any of the records you request. It's all there in your order. And the family code states that you're not required to produce anything else. This has become more of a problem, I would say, in the last year or so. I'm sure a few of you have had situations where especially counselors are refusing to produce records, even to the department, and are requiring subpoenas. Like I said, it's not required under the law, but you need to get them, and it's going to take longer for you. Eventually, the court needs to know this, right? But speak to the attorney ad litem or the assistant district attorney to explore the legal options, okay? Refusal of a provider to provide these records to you is also a violation of their service provider contract with 2Engage. So 2Engage needs to be told as well that they have a provider that's violating their contract. Any of the attorneys can send a subpoena and or have a conversation with that individual. Usually it just takes whoever their service provider liaison is at 2Engage to call them and say, it's part of your contract, you need to provide them. Hopefully you won't have to go through that because that takes a lot of time and energy that could be better spent elsewhere, but we're going to get them sooner or later. Unique issues within CPS cases. I believe that one of the CASA advocates actually requested to know a little bit about this because these came up for them in their case, which is all pretty interesting to come up together. When a criminal attorney enters the scene. So this can really, really change the dynamics of everything in a CPS case. I, for example, presently have a case in which both the mother and father were arrested for a very serious charge against a child. And we've just been waiting for criminal lawyers to get appointed. So my job up until a criminal lawyer was just appointed recently was basically to tell my client, don't cooperate and don't talk. My job switches when we have a serious criminal offense to making sure that they do not endanger their criminal proceedings, because then it's a liberty situation as opposed to a CPS situation. So when a criminal attorney comes in, you're going to have attorneys for parents really shut down, and all they're doing at that time is trying to protect their client until they can get direction from a criminal attorney. It's frustrating for everybody because it slows the process, but the reality is y'all are going to move on whether we say we're going to participate or not. When an application for a protective order is heard during a CPS hearing, during a CPS case, that can also clearly really change the dynamics of visitation and access and possession. There are times that the judge has ordered somebody to apply for a protective order to protect the children. If a protective order is applied for, it is not heard by your CPS judge. In Taylor County, that will be heard by Judge Patty Winnischlager. She's the other associate judge for the 326th. And that can really get confusing, and there can be a lack of communication when we have one judge hearing something and we still have ongoing proceedings down here. A protective order is good for 2 years. So let's say that we have facts in which a protective order is filed for the protection of the children against a father. Well, it doesn't really matter that he works as services. You know, if he does that successfully, if a court felt that it was dangerous enough that he not have access or possession of his children, nor be within 200 yards of them for 2 years, then that's what has to be abided by the CPS court and in that hearing. When a party requests a de novo hearing, so frustrating. And actually, it doesn't happen that often for us. So a de novo hearing means that you have an automatic right to rehearing because an associate judge is hearing the cause. So you have, and I'm sure you guys know this, but you have Judge Rotenberry, who is the district judge of the 326th. Then you have Patty Winnischlager, that is his associate judge, that hears protective orders, modifications, and other family matter things. Then you have Judge April Probst, who is the Child Protection Court judge, who's also an associate judge at 326. And then you have Judge Ken Leggett, that's the Title 4D Child Support judge, who's also considered an associate judge of the 326. So anytime an associate judge hears a case, you have an automatic right to have that case reheard by the district judge. You have to file that notice within 3 days of your hearing, and then that court has to hear that within 30 days. Judge Rotenberry's been very clear with counsel that you better pick wisely if you're asking to have a rehearing, because you know he has a lot of faith in his judges and rarely feels that there's a reason to rehear it. But you know, if I have a parent and they demand a de novo, I'm going to file for a de novo. And more times than not, when you have a de novo hearing, you're able to reach an agreement before you reach that point. But they happen. Tips from the bench. So I reached out to Judge Probst, and she provided these things. Judge Rotenberry said, he's good, y'all have got it. So he didn't have anything to add. But attorney ad litems and guardian ad litems should touch base before a hearing. So guardian ad litems know if they will be called on to testify. And if so, the attorney ad litem should help the parties if the parties are aligned. So for example, I represent mom, and you give me a call or I give you a call, we're getting ready for a permanency hearing. And I say, well, Penny Terrell, I'm going to have to put you on the stand, and you and I are aligned in what we want for the kiddo. So I'm going to let you know what questions I'm going to ask, the best way for you to handle it, things of that nature. Even if we're not aligned, I'm going to let you know, I'm going to put you on the stand, and I'm going to provide you some basic testifying tips. I'm not going to tell you what to say or what I'm looking for, but I'll let you know, just basically how to get through it. The judge, also share that if there's an issue regarding a child that needs to be addressed by the court and no hearing is set in the near future, reach out to the attorney ad litem or any aligned attorney to see if they will request a hearing. So this is not unusual, especially once we get to our permanency state or even placement states where that's only stages where that's only every 6 months. Especially, I mean, with any age kiddo, really, we're going to have issues that are going to need to be heard. So if you feel after we go through, what we talked about earlier, which was thread email, ask for a meeting, like things just aren't getting done. If it reaches to the level that you believe a hearing is needed, you just reach out to any attorney that's aligned with you and they'll file a motion. That's not unusual for me to do at all. And the court doesn't mind. The court would rather have us all come together and hear an issue than, just let it sit on the back burner for 4 months. And all parties should be informed and educated on attorney-client privilege. So this goes back to attorney ad litems for kiddos as well as attorney ad litems for parents. We cannot disclose what our clients say, and including our kiddos, and that can be frustrating for guardian ad litem. And it can be frustrating when we say, I'm sorry, Casa, I just can't discuss that with you. I can't answer those questions. And it's not personal on any level. It's just we literally, by nature of what we do, are just not allowed to do that. So not personal. And again, some lawyers are better than others at communicating this. So some attorney ad litems had some issues, and this is not saying that this has been dealt, they've come across this with anybody recently, but within the past. So it's important for everybody, and attorney ad litems have to be reminded of this too, that poverty alone is not a justification for removal or for delay in family reunification. Now, that's to say, of course, it's going to be a reason for removal if the child doesn't have running water or electricity, things of that nature that are actual and imminent threat to the child. But we have to remember that where we would want our children or our grandchildren or our nieces and nephews is not the standard, right? That's not what is required for a child to be sent home. And barring all other dangers to a child should be reunified and a family should be reunified. Another thing, and this is something that I run into a lot with the department and have made a stand on for a long time, so I think they just kind of expect it when we do our meetings, but not all parents need a substance abuse assessment, drug testing, and a psychological evaluation or assessment. We need to tailor these plans of service to this specific case. So if drugs was not a reason or part of the reason for removal, and or there was not some self-admittance to drug use, I'm going to take issue with that, or most attorney ad litems are going to take issue with requiring a service that was not an underlying cause for removal. That is not to say that an issue won't pop up during the life of the case, which I'm sure you've all experienced, and then that can be addressed. But each plan of service should be carefully tailored to the family so that we're not overloading parents with services that at the time is deemed that they may not need. Foster care involves risk, and that risk should be measured against the child's current circumstances. So often there are going to be cases where maybe instead of the court ordering the state to take temporary conservatorship over a child, we can do court-ordered services and leave that child in the home with closer supervision and services worked for the family. I'm sure you're all aware there is foster care is not a camp, and we have many children that experience a lot of trauma while in care for various reasons. And so that it really needs to be measured out. Is it so extreme that the child needs to be put into foster care, or can we find some other workaround where this child can still have contact with family, possibly stay with family and see family, but in a safe environment? Children attending hearings. This can be a delicate and difficult matter. So, again, if a child asks an attorney ad litem, tells them they want to come to a hearing, then that should be arranged. However, I will say there have been times where, as an attorney ad litem, if there's very sensitive subject matter, I'll just tell the kiddo, listen, I just don't think it's the best idea. You know, I can make sure you can talk to whoever you want to talk to, but I don't think you need to hear everything. That also being said, if you as a guardian ad litem want your child to be there, then they need to be prepared to hear everything that's going to be presented in court. The details, the facts, the testimony is not going to be tailored because the child is present. So I think we all need to work as a team to see really what's in the best interest of the child. And we can always make the child available to speak with the judge without having to sit through a hearing, which can be really traumatic. But there are times it's absolutely necessary. You guys are super valued and appreciated. Guardian ad litems, CASA, you often have more time to dedicate to the emotional well-being of these kiddos we're trying to help. And the bonds I have seen develop between clients and CASA in the past have been truly beautiful and amazing. And because of that, you guys may be the only really trusted adult in this whole mess that is their life as they navigate through this. And so I know that we as attorney ad litems, I know that the court appreciates you so very much for, I know you each go above and beyond, and it's emotional and it's exhausting, and what you do is really amazing. I asked for some funny stories from attorney ad litems, and I got one that was really great, but you guys are often much better equipped than an attorney ad litem to help navigate difficult and sensitive matters with a child. Hence, insert hilarious story of attorney ad litem that shall remain nameless. He said it's so comforting to him to have a guardian ad litem when he has to sit with a teenage girl and discuss the pros and cons of all of her birth control options. And that sometimes that's better coming from somebody other than, as he said, a balding white dude. So I think that often, again, because of that relationship, some of those sensitive topics are maybe smoother with you guys navigating the waters. Okay. How about a little Q&A? Someone stop sharing now? Are we good?
We are good.
Okay, so I'm going down to chat. Oh, that's a great question. Okay, so what parties are involved in court-ordered services? So when I have a case for a parent, because they don't give me enough kids, I'm about to send that email later today. And I believe that, yep, sure, they can benefit from some services, but removing the child out of the home seems extreme. Either when we can agree to that or the court agrees and orders that, it does change the dynamic. So then you no longer have the caseworker that you would have if there was a legal removal. It's going to go back to the safety-based services. They change their names all the time, FBSS crew. And that may be who this family was working with up until this point that they tried to get a removal. It'll go back to them. Now, the good part about that is that services can still be provided, but the department is very limited on what they can pay for. For example, I don't believe they can do the CCPO for daycare. The child will not receive the Medicaid, the Star Health Medicaid. So it's to have minimal involvement with the family, but provide them the services that they need, which should be on a minimal basis. That parent will get to keep their attorney ad litem, and that child will get to keep their guardian ad litem and attorney ad litem through that process. Because if you haven't already experienced this, sometimes those don't go real well, and we end up right back in court. If a parent has drug issues and is required to do drug testing, is it necessary for them to have a clean drug test before reunification can occur or visitation can occur? Or is it only necessary for the drug test to be done? Seems like the question is ridiculous, but I had a 2 engaged person tell me that they needed to research how it was written in the court order. Okay, so not crazy. I have definitely had the judge order before, all 3 of them at different times, order that a parent could have their visitation after just submitting for a drug screen. Now that's always going to be in a controlled environment. I don't believe I've ever had a judge say that could happen even when it was at a relative's house. That's when it's been at CPS. So if it's supervised, usually as long as they're testing, it's okay. But not not usually with a family member, right? So I have not had a reunification with a hot parent that was still in the picture. So I say hot parent, a parent testing positive. Try to not use my slang. Um, so that would be extremely unusual to me. And you know what? God bless you guys. God bless us all. This transition to engage, it's something. I just got off a phone call before getting on with you guys with an investigator who said that, it's her job as part of an investigation of an already open CPS case to drug test a party, but to engage couldn't share their previous drug screens in an open case with this investigator. So there's a bunch of growing pains that makes you want to pull your hair out, bring it to the attention of the judge. She'll get down to it, because growing pains or not, kids don't have to pay for it.
Erica, the next question's mine. It's actually two, but when I
Okay.
hit enter, it ran them all together. So one of them, it's two different. You'll kind of see.
Okay. So reasons we might need to request an extra hearing. Okay. Okay. So, for example, I have requested an extra hearing in alignment with ACASA before, because CPS, and when I say CPS, I mean to engage and CPS interchangeably until I'm trained better. Let's say they want to make a change in placement and we don't agree with it, but their policy dictates that that's what they're supposed to do. Then I've done that numerous times where I've just gone ahead, reached out. They weren't in agreement. I said, no problem. Filed a motion for consideration of placement with the court, got a hearing set. And what that will do, at least every time I've done that, is put the brakes on any change in movement, because it's going to look really bad if they know a hearing's been requested and they go ahead and do whatever the action is that you're seeking to have addressed before the court hears it.
Okay, good.
Does that answer that?
Yes, I asked that one because we actually had to do this recently on my case, Sarah Tennyson, because they were not doing what they needed to do at this RTC, and
Yeah.
we couldn't get calls, we couldn't get communication, couldn't get services, so we had to bypass and go straight back to court.
And I'm about to do that because of an RTC as well. So, and then part of that, I think when we're dealing with placements like RTCs that are contracting you guys with to engage needs to be made aware of this. And they need to know how serious it is. And because, depending on the seriousness of it, we may not need to have kids placed there. Years ago, I had a really, really young child placed in an RTC in Houston and finally said, enough is enough. This is not okay. And they ended up getting shut down by the state like 4 weeks later. So listen to your guts and, your instincts, and just speak up if you think there's an issue. But yeah, never hesitate. There will be somebody willing to file for a hearing for you.
Okay.
Oh, okay. Yes. So good question. Clarification on a de novo hearing. A de novo hearing is, we talked about that it's, let's say Judge Probst hears it and I file a de novo because my client wants it, then it's going to be Judge Rotenberry who hears it always. Unless he's off the bench for some reason and there's a visiting district judge. But that's how a de novo works, is that a district judge must hear it.
Okay, good.
And then there's nothing you can do about it at that point.
Yeah.
Until it's final and you can go to the Court of Appeals and find a lawyer who does that, because it's horrible.
Okay.
Oh, okay. Recognizing that all attorney ad litems are extremely busy, what tips do you have if a child's attorney is unresponsive? Well, I hate it whenever I hear that that's happening. I mean, I know we're all guilty of it, just human nature, but also as lawyers. I find that, like I said, email is the best. I'll text with you all day long, because I can do that if I'm folding laundry or if I'm getting ready for a hearing, right? Most of the lawyers I know are willing to text. I think that's a really good way. If they continue to be unresponsive to a point where it is negligible, you need to let your CASA supervisor know. And then I am guessing, will have a discussion with the assistant district attorney or with the judge themselves. You guys don't go through the ADAs anymore, really, because you don't need to. CASA has its own standing relationship with the courts now. And so I would think if it came to that they would then, however your policy is, Rebel, then address that with the court as needed. Because it's not okay.
Good question. Okay, guys, what other questions do you have for Erica? And while you're thinking about it, you can chime in or you can type it, either one. Erica, I'm going to have you pick a couple numbers for me real quick.
Ooh, okay.
One between 1 and 21.
21, because it was a super fun year.
Woo! All right, that is for Byron Smith. I think Byron's still on here.
Yay,
Yep.
Byron!
Yay, Byron. I
Tell him
think
what he got.
he got an awesome mug. He's one of our new advocates. He trained during COVID, Erica.
Welcome, Byron. Thank you.
So that's yours. And then it'll be up here at the office for you, Byron. And then if you can pick another number between 1 and 20.
I'm not even good at gambling, you guys. So like 5?
That's perfect. 5, Ashley Hart. You've got this little phone button, pop-up button for your phone.
Pop socket.
Yep, those are great. It's got pop on it. So this will be up here in the hallway waiting for you. And one more, we have a little CASA pin that they can wear. Normally we say wear them to court, but we're not going to court, but they can put it on their lanyard or anything.
12.
And that is Ronalyn. Ronalyn, this is for you.
Where are you?
So Ronalyn trained last fall, I believe. So anyway, those are for you guys, and that's it. So do we have other questions, guys?
Let me double check the chat function again.
I love your mom. Good
Oh,
job.
thanks, Mom.
So
My
did you
mom said
tell
I
us
did
that your mom became a CASA how long ago?
Gosh, when they moved here. Mom, are you on here? My mom's Penny Terrell, if any of you know my mom. After they moved here and got settled, 3 years?
I think so.
She's refusing to be on camera.
Oh, that's okay.
Do I hear you, Penny?
It'll be 4 years in the spring.
4 years in
4
the
years in
spring.
the spring.
She's
So
a great advocate. Penny is fun too, let me tell you.
I get to hear how much we're alike at the courthouse.
You are.
I don't know if that's good for both of us, not good for both of us. I don't know.
Well,
Oh,
do
and
go
the
ahead.
last frame of my presentation, if I can go ahead and share it again, is that okay? It has all my contact information.
Okay.
Do not hesitate to contact me about a question, how to handle, I mean, anything. As long as you don't give me names, you're not breaking confidentiality. So I'm here to help, and I'm right across the street from the courthouse. But let me share my screen again and give you guys that, because I had it all done. There we go. Next. There we go.
There we go.
So you guys feel free, email me or call me. I wouldn't offer if I didn't mean it.
Well, and
Ask anybody at my house.
Erica is very, she just knows it. She knows her stuff. She knows CASA well. She knows our relationship well. She knows what we can do, not do. So guys, she is very, very helpful if you need anything at all. And Erica, we so appreciate you.
I appreciate you guys, and thanks for letting me do this. I
Oh.
get nervous. I get so nervous every time, but that's probably a good thing.
Well, you're awesome. Your mom is right. You did a great job, and you are awesome. And
Thanks, guys.
round of applause.
Thank you.
Thank you.
Okay, let's go advocate. Everybody have a great Tuesday.
Thank you, guys. We appreciate you all, and that's the end of the meeting. We'll get everything entered for you, and I'll send out the link in case you want to go back and review any of this by video. Thank you all. Oops, I got to stop recording.